In 1913, the foreign minister of Honduras wrote to the British consul general asking for a ship of war. Revolutionaries were using 14 small islands in the Gulf of Honduras as a staging ground. In that letter he called them, quote, islands belonging to the colony. Honduras' own government asked Britain to police these islands as British territory. That was 1913. In 2026, Honduras is fighting for those same islands at the International Court of Justice, and they're not the only ones. The Sapodilla Cayes, 14 small islands at the southern end of Belize barrier reef. Sand cays and mangrove, roughly 75 kilometers east of Punta Gorda in Belize's Toledo district. These islands are tiny, but what matters isn't the land, it's what surrounds them. Under the UN law of the sea, an island generates a 200 nautical mile exclusive economic zone. Fishing rights, seabed resources, potentially billions in revenue. But there's a catch. Article 121, paragraph 3 says rocks that can't sustain human habitation or economic life don't get an EEZ. They only get 12 nautical miles of territorial sea. If these are rocks, Belize gets a maritime zone the size of a city park. If they're islands, they control a blue footprint of 125,000 square nautical miles, enough to swallow the entire Persian Gulf. Belize points to Hunting Cay, where they run an immigration office and perform Coast Guard patrols, and to the Cabral family, documented on Lime Cay since 1873. Inhabited islands, not barren rocks. Whether the court agrees determines whether these islands are worth fighting over. Spain claimed the Gulf of Honduras as part of the Captaincy General of Guatemala, but claiming and administering are two different things. Spain never built anything on the Sapodilla Cayes, never stationed anyone there, never collected taxes. Logwood cutters had been working the coast since the 1600s. In 1786, Spain and Britain signed the Convention of London, which gave settler rights between the Hondo River and the Sibun River. The Sibun is well north of the Sapodilla Cayes. Britain wasn't supposed to be that far south, and Spain kept sovereignty. The convention said the land was indisputably acknowledged to belong of right to the Crown of Spain. The British were concessionaires, not rulers. Then in 1798, Spain tried to kick them out. The Battle of St. George Cay. Spain lost and never effectively reasserted control. Over the next 3 decades, British settlers pushed south, past the Sibun, past the Mojo River, all the way to the Sarstoon by 1825. And in 1859, Britain and Guatemala made it official. The Wyke-Aycinena Treaty drew a land boundary from the Sarstoon River to the Mexican frontier. 6 articles, specific coordinates, rivers, geographic features. But the treaty said nothing about offshore islands, nothing about maritime boundaries. During the negotiations, it was considered unnecessary to describe the sea frontier. That omission is the reason there is a separate dispute with a separate ICJ case today. For 200 years, Britain administered these islands without a challenge. Magistrates ran criminal trials, they built lighthouses, granted fishing licenses, suppressed piracy, and stationed military patrols. And in 1913, the letter I opened with, Honduras confirmed all of it. On September 8, 1913, Mariano Vázquez, the Honduran foreign minister, writing on behalf of the president, sent a letter to J.P. Armstrong, the British consul general. Honduras was worried that revolutionaries were using the Sapodilla Cayes as a staging ground, so they asked Britain to send a ship of war. And in that letter, Vázquez called the Sapodilla Cayes islands belonging to the colony. Honduras' own government asked Britain to exercise its sovereign police power over these islands. That's not ambiguity. The letter was a confession. So what happened between 1913 and 1982? 3 things, all at the same time. First, Honduras was writing a new constitution. Article 10 lists Cayos Zapotillos, the Honduran name for the Sapodilla Cayes, as national territory. Article 11, right next to it, defines a 200 nautical mile exclusive economic zone. The constitution entered force on January 20th, 1982. Why then? Belize had just become independent. On September 21st, 1981, British Honduras became Belize. Challenging a small new country is different from challenging the British Empire. 6 months before independence, Honduras sent its first diplomatic note to the British ambassador on March 17, 1981, reserving the right to have recourse to all means established by international law, first formal claim in 160 years. And a week earlier, on March 11th, Britain, Guatemala and Belize had signed the heads of agreement, which proposed giving Guatemala use of the Sapodilla Cayes. Honduras panicked. Meanwhile, the United Nations was finishing the Law of the Sea. UNCLOS created the modern EEZ framework. Whoever owned the Sapodilla Cayes would control massive maritime zones in the Gulf of Honduras. The economic incentive to claim tiny islands went from zero to billions overnight. No historical claim, no colonial documents, no acts of administration, just a constitutional assertion. Unlike Belize, which inherited 200 years of British lighthouses and magistrates, Honduras's claim started and ended on paper. The claim was born on paper, not in history. In November 2022, Belize took Honduras to the International Court of Justice. Case 185. Sovereignty over the Sapodilla Cayes. Belize's position is straightforward. 200 years of uninterrupted, peaceful possession. Lighthouses, criminal courts, a marine reserve. 226 illegal fishers prosecuted between 2004 and 2008, including Hondurans and Guatemalans caught in those waters. Honduras' position, Article 10 of their constitution, and silence on everything before 1981. Then, Guatemala kicked down the courtroom door. In December 2023, Guatemala applied to intervene. Their argument: the Sapodilla Cayes are part of their broader territorial claim against Belize, the one where they claim half of the country. If the ICJ ruled on these islands without Guatemala in the room, it could prejudice the bigger case. And Guatemala had a point. If the court says Belize owns the Sapodilla Cayes, that simultaneously denies Guatemala's claim to those same islands, even though Guatemala isn't part of this case. The court can't decide a bilateral dispute if doing so requires ruling on a third party's rights without them present. Honduras called the intervention redundant and an abuse of court procedures. The ICJ only has power because sovereign nations consent to it. You can't force a country to litigate against someone it never agreed to face. But Guatemala had a point too. You can't rule on these islands without ruling on their rights. The court was trapped in a catch-22 of its own making. Reject Guatemala, and the whole case collapses because you can't rule without a third claimant present. Accept Guatemala as a full party, and you've broken sovereign consent. On March 19, 2026, the court threaded the needle. Guatemala was permitted to intervene, but strictly as a non-party, and only on the question of sovereignty. Under ICJ rules, a decision only binds the parties to the case. Guatemala is in the room, so the court can proceed without ignoring their rights. But Honduras isn't officially litigating against them. Consent preserved. The court's own words: Guatemala's interest is real and concrete. So why would Guatemala spend years and millions in legal fees fighting to sit in a courtroom where the ruling won't even bind them? They're there to stop the court from building a legal record they can't undo. Without Guatemala in the room, Belize presents its evidence, and if no one challenges it, the court accepts it as indisputed fact. A 200-page ICJ judgment explaining why Belize's history of possession is legally flawless creates a wall Guatemala can't climb in 2027. As a non-party, Guatemala can now submit written observations and challenge evidence in real time. They can introduce alternative interpretations of the 1859 treaty before the court locks in Belize's version. Guatemala's main argument is iuki possidetis juris. Colonial borders inherited at independence. Guatemala says it inherited sovereignty over these islands from Spain. The 1859 treaty either didn't cover them, or it's void because Britain broke Article 7. Either way, the territory reverts to Guatemala. After that, Belize has the 1913 letter, the 200 years of administration, and Honduras' own government calling these islands British territory. The same judges hearing this case will eventually rule on Guatemala's claim to the Belizean mainland, and the reasoning they develop here about Spanish colonial succession, about what counts as effective administration, carries straight into that case. The ICJ just allowed a country to sit in someone else's courtroom, not as a party, not bound by the ruling, purely to stop the court from building a legal record it can't undo. That's only the 4th time in 80 years the court has done this. Fishermen from Punta Gorda, 75 kilometers from Sapodilla Cayes, still depend on these waters. 3 governments are now fighting over where they can fish. None of these governments ask them. The main case, whether Guatemala gets half of Belize, is expected in 2027. I'll cover it when it drops. Please subscribe if you want to follow this case.